Hi, everyone. Welcome. I did not hear a beep, but I heard a spiel. Hi, good afternoon. I'm Sara Nash. I'm here with Sara, my colleague. Today, we're discussing multi-jurisdictional employers, part three. We've already had two series where we talked about independent contractors and non-competes, restrictive covenants. And today, Sara and I have the pleasure of talking to you about best practices for paid sick leave and family leave. Heads up, apologies in advance. This is a complicated area of the law. There's a lot of moving pieces, but we're going to try to deliver it as straightforward as possible. We welcome your questions. So without further ado, because we've got so much material to jump into, we're going to let's get started. I'm Sara Nash again. I am a partner in the Labor and Employment Group at PilieroMazza. We are often, I feel like I've already done three of them today, talking with clients with calls about how you navigate the ADA, how you navigate sick leave, and FMLA, and all of the state-specific requirements. And because we're always dealing with folks on those issues, we thought it'd be helpful to put one of these webinar presentations together just to walk through sort of what folks, managers, HR professionals, companies should be thinking about when people come to you with certain leave requests or certain needs for different types of accommodations. I'll let Sara introduce herself.
Awesome. Yeah, thank you, Sara. And I am Sara as well, Strosser. I work with Sara and the rest of our labor and employment group on exactly the types of things that Sara mentioned. Obviously we spend a lot of time working with clients on policy review and just asking or answering rather tons of questions. I'm compliant with all these states that I have employees in, and obviously as contracts grow and your workforce grows, so do sort of the obligations that you need to abide by. So I think Sara can probably agree that this is what we do day in and day out, and so we see a lot of the nuances, and obviously this is sort of what sparked the idea of doing these presentations, was because we're seeing a lot of employers start, having their workforce in a lot of states and having to deal with these state-specific laws and regulations. So paid sick leave and family leave being one of them. Next slide here is a little bit about our firm. Obviously, no need to necessarily go through all of this, but we are sort of a full service law firm. A large portion of our clients are government contractors, but we do have non-government contractors as well. And as you can see, we do tackle a lot of different areas, including, of course, labor and employment, which is the practice group that Sara and I work in. And today, so I think, this is a very bare bones list of what we're trying to achieve with today's webinar, but I think essentially what we'd like to do and hopefully have you walk away with is sort of an understanding of what are the types of leave, right? What kinds of things are we looking at and having to discuss and consider. And then discussing to some extent the state-specific requirements and more so just how are we going to navigate the different requirements. We'll talk about, what's protected leave versus paid benefits. And also on that same token, sort of what is permissible leave versus what is protected leave, right? And then I think the big sort of area that we'd like to focus on, and I think probably the area that most folks have questions on, I assume, are sort of what do we want to think about when we're drafting leave policies, right? So because there's all of these state-specific rules and regulations and different types of leave, what are the things that we really ultimately need to take away when, we're pulling together our leave policies and making sure that, we're compliant and across the board, right, across the nation.
And before I forget, jumping in, that this is eligible for HRCI credits. So we'll be circulating that code at the end of the hour. And then the slides and the presentation will be made available afterwards. You should be receiving an email. So just wanted to get those administrative pieces out of the way before, Sarah, you jump in and explain to us the difference between protected leave, permissible leave, and all that fun stuff.
Free. Sarah and I are going to try to keep this as conversational as possible. Ultimately, we'd like your input, your questions. I know, some of you may have specific questions already on the top of your minds. So feel free as we're going through this presentation to inundate us with all of your questions or comments, or if things aren't clear as we're talking through these, please feel free to go ahead and input your comments or questions, and we'll do our best to answer as we go along, and if not, then we'll hopefully be able to reach out to each person individually with their questions. So go ahead and take advantage of that chat and question box, and we'll try to answer as many as we can. But to get things going, we'd like to talk about sort of the difference between protected and permissible leave, right? So what are the types of leave that are required by law, i.e. protected leave, and what are the types of leave that you as a company will be offering voluntarily, right? So i.e. the permissible leave. And the reason why that's important, or to understand sort of the differentiation, is that there's sort of different rights and expectations that attach to the different type of leave, right? So if you see on this chart, I think we tried to lay it out as plainly and simply as we could, but on the left-hand side with regard to protected leave, we're talking about leave, again, that's required by law, whether by state or federal law. On that same token, employees have certain rights while they're on leave, right? So for example, they have a right to maintain job security while they're out. There's no leeway with that leave, right? So assuming that all the requirements are met, you are to grant that leave to them, right? Like, you don't have a choice. It's not at the company's discretion. You must grant that leave, assuming, again, that those requirements for that specific type of leave are met. If you don't, then you can face legal consequences, whether that is penalties or violations, right? There are certain consequences that you could face as a company if you don't provide that leave. And we'll talk through examples a little bit more in the next few slides, but the things that we're thinking, and I'm sure you can kind of think off the top of your heads, is FMLA, military leave, state-specific paid leave laws, right? Whether it's sick leave or paid family leave. So those are the types of quote-unquote protected leave that we're talking about. On the right-hand side of this chart, we want to consider permissible leave, right? So what are the types of leave that you as a company can offer to your employees voluntarily, right? So it's at the company's discretion. You're not mandated by law to offer these types of leave. And the rights that you offer are limited to the company policy, right? So what sorts of rights are you affording to your employees for these types of leave? They're not mandated by law, but they're the types of things that you are just, as a company, deciding, for the benefit of your employees, are providing to them. There's no legal consequences because there's no legal obligation to provide these leaves, these types of leave, unless, of course, there's some showing of discriminatory behavior on the part of the company, right? Otherwise, there's no obligation to provide this leave, and therefore no consequences if you do or do not provide this leave. And the types of leave that we're generally talking about here, again, we'll talk more about it later, but are, your sick leave, unless, of course, it's mandated by state-specific laws, your vacation, potentially like disability leave, right? Things like that. Again, there could be nuances depending on the state that you're operating in, but those are the types of things that we're talking about. So that's sort of a general idea of what is protected leave and what is permissible leave, and that will sort of set the foundation and how you're going to draft your company policies and the types of things that you need to consider.
And just to piggyback on Sarah's conversation about that, so when you are operating in a lot of different states, one of the first things that's important is to understand exactly what those state requirements are going to be, because they do vary. Some things that are never going to be required. We'll often receive questions from clients like, how much vacation do I have to provide? How many holidays do I have to give? There is not a single state out there, just doing my little calculus in the back of my head, that requires vacation. There is not a single state that requires holiday pay. Um, there are some industry requirements, like if you have SCA employees, you might have some obligations to provide holiday or vacation. But otherwise, states generally stay out of that. There are state sick leave obligations. I haven't done the math recently. There's about 14, 15 states. It's growing on almost, it feels like a monthly basis. States out there that do obligate private employers to provide sick leave. There are also a growing number of states out there that have their own state-specific FMLA requirements, that have their own specific paid leave benefits that they offer to employees. And so you'll see us, we're going to go through some examples, but every single time we're going to start at what's the state of employment. We're going to go through those specific state requirements, and then we're going to tease that out a little bit from what the company policies are. Because just because you're not required to offer vacation, once you do offer that vacation, that might have its own additional sort of bag of tools and obligations that you might have to apply in that instance. And so as you'll see, the decisions start to layer up, and we're going to try to present it in a way so that it's sort of like, kind of like formulaic. First you look here, then you look here, then you look here, and that'll help it feel a little bit more natural as we walk through the different considerations at play. Yeah. Kaylee, thanks. I think we can go to the next slide. I know, I just snuck in there at the little last table.
But no, that's a great point, Sarah, because I think, the good news and I guess the bad news is there is no one size fits all policy, right? Like, we're not going to be able to have a template policy that works for every company. It's going to really depend on a lot of different factors, that we're going to be talking about in this presentation. And I think, the idea here is to hopefully provide some sort of framework or a path by which you can sort of use and navigate as you're considering how to pull together your policies. But I think a big part of this, to Sarah's point, is, let's understand what the foundational things are. What are the things that we need to provide versus wish to provide? And then what sort of additional considerations do we need to make, i.e. what states are we operating in? What things have we provided already? How are we going to message these to our employees and so forth? So,
and I do need to make a correction. A very responsible listener did just remind us that there are states out there that do require vacation. And I completely forgot. And a couple of them have been around for a minute, so I should have known. Illinois and Nevada have, at least for the last couple of years, they did issue legislation either last year or the year before that requires certain PTO policies. And Maine, I don't think I knew about Maine being added to the list. So thank you very much. You are absolutely right. There are a couple of states that are starting to make those requirements. Good reminder that these things are developing very quickly, and there are a lot of changes happening. So it's important to stay ahead of that. I'll also add that a lot of these changes in law can be accommodated by current PTO or vacation policies. Generally, best practice, employees have grown to expect it, right? Often, what's my vacation policy? What's my benefit? How many holidays do I get? So those are things that are generally standard, depending on the industry. But there are some additional, every year, there's going to be some new requirements that you have to stay on top of if you're operating across a lot of different states.
Yep, absolutely. So sort of talking, and we've talked a little bit about these examples already, but the types of things that we're thinking about as far as permissible leave are, let's say, sick leave, vacation, with a caveat of unless there is a state law that requires otherwise. And then flexible leave, we're really talking about unlimited leave policies. I'm sorry, Sarah, I know I jumped in right there when you were.
No, you had just frozen for a second.
Nope.
So I was.
Oh, sorry.
How long it was going to go. You're good.
Okay, good, great. So these are the examples. And then on the next slide, we have examples of the protected leave, right? So these are the leave types that are required by law. So again, we're talking about the sick leave that is required by state specific regulations. Your family and medical leave, right? Your FMLA, that's required, assuming that you meet, the eligibility requirements for both the employer and the employee. Or there are state-specific paid family leave laws right now that we're seeing sort of a growing patchwork of across the nation. And then your Americans with Disabilities Act, your ADA, right? And obviously, under the ADA, you're going to have to make the sort of go through the questions, right, of whether or not an ADA accommodation or ADA leave is going to be approved. And the types of things that you want to think about are, when is it reasonable? Is it not going to cause an undue hardship on the company? And can that individual still perform the essential functions of their job with the accommodation, right? So those are, again, just different buckets of leave, but obviously very differing as far as what your obligations are as a company, and whether or not you actually have an obligation or a law or statute or something that mandates that you provide those leaves types.
I'll also add that is not one size fits all. Just because something qualifies for sick leave doesn't mean necessarily that it qualifies as a disability under the ADA. Someone going home because they have a headache for the day isn't necessarily going to rise to that level of, qualifying as a disability under the ADA. So these are things that are also sort of should be peppering whenever we're asking questions. We're trying to figure out, okay, what's the reason that they're out? Could it be construed as a disability? Is it a serious illness under the FMLA? All of these laws, funnily, have different sort of definitions of what qualifies. So sick leave, for example, generally states more or less have similar rules and requirements for when sick leave has to apply. It's for the employee's illness or the illness of a family member, which depending on the state can vary a little bit. And then it's generally also available for not just illnesses, but medical appointments. You might have sexual assault provisions in there that are pretty typical depending on the state, domestic violence provisions. And it's important to be familiar with those state-specific requirements because they do vary sort of case by case. Looking at family and medical leave, so FMLA requirements or state-specific requirements, those kind of are a different subsection. Often they can overlap with sick leave coverage, but often they also include a little bit of a different nuanced serious medical condition. Not only that, but for family medical leave, you also can be covered for leave related to a family member. But ADA leave, Americans with Disability leave, doesn't cover leave related to a family member. So it's helpful to sort of write out specifically what is the reason that this employee is out, and that's going to help inform a lot of sort of the calculus as you work through how to evaluate these types of employee requests. I will also add that it varies state to state. It varies employee. Those specific circumstances are going to be important. And especially when it comes to accommodation questions, it's really going to come down to sort of the reasonableness of the request. And so again, we're going to work through some examples that help people think through how to look at these types of questions. But it is, I warned at the top of the hour, it is a very complicated area of law that it's not going to be one size fits all. Every time you're going to have to look at the very specific circumstances involved.
Yep, absolutely. So the next slide talks a little bit about sort of the benefits while on leave. So, what kinds of things can employees receive or may be entitled to while they're out. And the sorts of things we're talking about here obviously are a short-term disability or long-term disability, workers' comp, right, assuming the injury occurred, at the workplace, your state disability plans and things of that sort. These benefits obviously don't provide job protection, but they are things that, could be afforded to the employee, again, depending on the circumstances.
Yeah, we'll often get questions from folks saying, well, they went out on DC paid family leave. Um, when do I have to reinstate them? Or they're on short-term disability or long-term disability. How long do I have to keep their position open? And those are really two separate issues. These benefits that are laid out on this slide do not provide job protection. They might be like tied to types of leave that are job protected. So someone on short-term disability could be covered under FMLA, or someone who's participating in a state disability plan. There are a number out there. DC has one, California has them, other states. Someone who's on those disability plans could be otherwise covered by state or federal protections. But it's important to think of them as two different things. One is how the employee is getting paid, and the other is the company's obligations to that employee to either reinstate them or accommodate them or go through some other process with them. And so as we think through this, it's really important to remember that things on this list, even workers' comp to a certain extent, your benefits provider might recommend that you reinstate them because it ends up ultimately being cheaper. But generally, the list on this page are not going to be tied to, keeping the position open, reinstatement, how long you have to go without someone in that position.
That's right. Okay, let's talk through an example on the next slide here. Again, there's not, one answer to these questions. These are just, it's for brainstorming purposes and just to sort of get a sense of how many things can come to play in just a very basic types of situation. So in this example, and let's assume an employee gets in a car accident while at work, needs 6 weeks off, and then needs intermittent leave to attend appointments. So pretty basic scenario. And so the things that we sort of want to think about first off is what types of information or what information do you need to sort of begin this process, right? And there may be a lot, right? So I think, one thing that we talked about is, first of all, figuring out what position is this employee in? Are they able to continue doing their job even after the 6 weeks are off? Based on their job duties and things and based on, right, the extent of their injury. But, let's think about first step, who is this employee and what is their job duties and responsibilities. And then we sort of get into sort of the medical information. So I know Sara, you can probably speak to a little bit more of like, what are the types of medical documentation? What are the types of things that we need to consider to then evaluate what type of leave we want to provide?
Of course. So yeah, we're also going to want to know, like, first of all, are they out because of this car accident? Is it related to is it workers' comp related? Were they performing job duties when this accident occurred? What state was it in? Because you need to know whether there are state, for example, California, their state sort of version of FMLA kicks in automatically. You don't have to be there for a period of time. And so there are different state sort of questions that we want to make sure that we're considering. But so first you're going to know where it's occurring, like Sara said, their job duties. You also want to know if they have PTO available, like if they have sick leave, what type of, if you're performing work on a government contract, what type of contract are you, such that, like, are you still going to get paid even though you have a vacancy in the position? These are all just kind of high level things that are probably going on as you're trying to accommodate basically 6 weeks off. And the state specific requirements are going to kind of inform that question. Mm-hmm. The next piece, and it's sort of like 2 periods of leave, right? We've got the 6 weeks of leave, but then we've got intermittent leave for appointments. I think for that purpose, we really need to know, like, are these appointments going to be all day? Are they going to be a portion of the day? Can they be scheduled around the employee's schedule? Just sort of figuring out programmatically how you're going to begin to look at this. And so those are the other sort of data points that are probably going to be helpful as you evaluate this type of request. Sara, so since we've got it on here, what types of leave through all of that might apply, do you think?
Yeah, so I mean, I think we want to consider, obviously, is FMLA an option, right? We have to assume, or not assume, but determine whether or not the employee would even be eligible, right, based on the FMLA eligibility requirements. But that could be an option. We may want to consider leave under the ADA, right, especially the intermittent, or is that going to be an accommodation that we can provide as an employer to the specific individual? Is it going to cause an undue hardship? Are they going to still be able to perform the essential duties of their job, right? That's where the duties question comes into play. What else can we think about here? What am I missing?
They might have some sick leave available.
That's right.
Which is going to cover at least payment for that period. If they've got, a lot of these states sick leave requirements require carryover year after year, although some do allow for caps on carryover or caps on use or caps are on accrual. It might be that someone's got, 3 weeks of sick leave that they're going to be able to be paid for during that time off. So that's the only other thing that I could think of that might apply.
Perfect. And as far as benefits, I think the accident happening at work always, right, that always sort of should trigger potentially workers. Perhaps, I assume in this case, assuming all the facts line up, that workers' comp may be available to this employee.
And if they're covered by FMLA, remember that FMLA requires continued benefits. So you might be in a position, because it's 6 weeks off, that's going to be longer than the month of their benefit coverage. Very likely you will have an obligation to provide benefit coverage for that duration of their leave as well.
Exactly. And as far as documents, again, this would depend on the type of leave that would apply in the scenario. But, if it's FMLA, then obviously the FMLA paperwork. If it's ADA, the ADA paperwork. So you'd probably want to start with the type of leave that applies. And then based on that type of leave, then you would, provide the corresponding paperwork.
I'll also add that it's important, if you have an employee, if you as a company are covered by FMLA and your employee qualifies for FMLA leave, it's really important that you start that process as soon as you think there's a likelihood that they have a serious medical condition, or that they are otherwise qualified for FMLA coverage, whether it's for a family member or a pregnancy or parental leave, whatever the sort of calculus is for that might cover FMLA. You want to start that clock as soon as possible, because you want to essentially get credit for the employee taking those FMLE hours. If you wait and you don't, let's say someone goes out for 2 months on some type of medical leave and you haven't classified it as FMLA leave, that could essentially entitle that employee to another 12 weeks of FMLA leave later on, just because the company didn't classify that initial absence as FMLA. So it's important that you as a company get credit for those leaves of absence, so that you're not caught in sort of this perpetual circle of always essentially needing to offer more than 12 weeks down the line.
Yep. So what seemed like a very basic example, obviously, a lot of different things to consider, a lot of different types of leave that may apply, right? So I think this is a perfect example of sort of what we're talking about here, right? Like there's so much that we need to consider. There's so many nuances, and it's going to be very fact specific, right? So depending on the type of employee, what exactly happened, where it happened, what the leave request specifically asked for, right? There's going to be a lot of things that will need to be considered to then determine how best to move forward. So the next slide here, we're going to talk a little bit about sick leave. Of course, with the caveat that we're dealing with a lot of, growing list of states that have paid sick leave requirements now. And so, depending on where you have your employees in, you're going to want to make sure that you understand exactly what those requirements are in those states and making sure that your policies are compliant, or as we'll talk about a bit later, you have one policy with specific state addendums that tackle each of the state specific requirements. But Sarah, I don't know if you want to talk a little bit through the sick leave portion here, but
Yeah. So there are a lot of differences that apply, but there are also some similarities. And so generally, some of the similarities we've seen is basically depending on the company size, you're gonna have to offer somewhere between 5 and 7, sometimes 9 days of sick leave to your workforce. Again, depending on the state, depending on if you're covered by the Service Contract Act or Davis-Bacon Act or some other quirky federal contractor requirements. So generally, if you've got either a sick leave policy or a vacation policy that covers that amount, you're at least providing sufficient leave to your employees. Generally, we went over earlier some of the common reasons that are protected for sick leave. So the employee's own illness, the illness of a close family member, and some other reasons that might go on that list. And generally, we like to see that list sort of laid out in the company handbook or leave policies, somewhere where employees have clear insight into what's covered. Other sort of common threads in sick leave include the increments, which employees need to be permitted to use the leave. Generally, 1 hour increments is safe. There are a couple of states that might require larger increments or permit larger increments, like a half-day increment, but 1 hour generally keeps you on the right side of most state requirements. And then the other thing that we also touched on is this question of carryover. And there's basically 3 different ways to think about how employees can keep and hold on to their leave. One is, are you allowed as an employer to put a cap on carryover? Another is, are you allowed as an employer to put a cap on use? And a third is, are you as an employer allowed to put a cap on accrual? And there's, of all the states out there that have these sick leave requirements, frustratingly, they're all different. And so it's important to look at the nuances of that state law to make sure that you are complying with those obligations. I'll add that as far as enforcement, I haven't seen a lot of crackdown on PTO policies that are maybe a little bit more generous in some respects, but do put a cap on carrier or do put a cap on use. It doesn't mean that it's not happening. It's just not been something that's been top of the enforcement mind as we've been looking at a lot of these complaints that have been coming in over the past few months. The other sort of thing that I'll add, as I mentioned, you can satisfy a lot of these state sick leave requirements with your PTO policy. So this doesn't necessarily mean that you need to give all of your employees like double the leave that they're currently receiving. You just need to make sure that it's compliant with those state-specific requirements. I will also add that we've got a lot of clients who have CBAs, collective bargaining agreements with their workforce. And those CBAs aren't always compliant with the sick leave requirements. By now, most state laws require compliance regardless of whether you have a CBA in place. So it's important to make sure that one, there's no carve out for CBAs to the state requirements, and two, just understand exactly what those state requirements actually are. I will also add that a lot of policies that review don't have sick leave for part-time employees. I think that's just sort of standard. A lot of part-time employees don't get the same benefits as their full-timers, but most every state law requires that part-time employees also accrue sick leave. So to the extent that you don't have your part-timers covered under your standard PTO policy, you've got a couple options, right? One, you could encompass some of those PTO accrual policies, just add those on for your part-timers, or you could just have them subject to a separate sick leave policy for your part-timers. So there's a few ways to thread that needle, but ultimately, you just need to make sure that you know what those obligations are and figure out how you would like to satisfy them.
Yeah, I mean, I know, Sarah, we talk a lot about DC just because by virtue of, where our clients are, but DC is one of those, sick leave laws that both part-time and full-time employees are eligible for. And I think we run into a lot of issues when we're talking through this stuff with clients and policies, especially when you have employees in DC, make sure a lot of fruit issue that we spot is they just don't have sick leave applicable to their part-time employees. So if you're operating in DC, that's not going to be compliant. And so, that's one big thing that we tend to look for is, what does the law require as far as who is eligible for the sick leave? And, are you providing that sick leave to the entire subset of folks that should be entitled to it? So, sort of an easy one to make sure you're compliant with, but it's a big one. And we see a lot.
I'm a technology troglodyte, and I just realized that we have a bunch of questions that have piled up, and I just wasn't looking at the right page. So I'm going to go through a couple of those. Some of them are very on point, and I think it'll just be good for the group. One of the questions is if an employee works from home. I think we might actually have this question later on in the webinar. So this is whoever asked this question, you are ahead of the curve. If an employee works from home in Colorado for the company based, let's say the company is based in New Mexico, which state requirement do you follow? Do you follow New Mexico? Do you follow Colorado? Most requirements, and we might have lost, oh, she's back. Most requirements apply to the state in which work is performed. So if you've got an employee working out of Colorado, it's Colorado sick leave that's going to apply. Regardless of where the company is based, regardless of where the contract is based, it's going to be like, where is that employee physically sitting that controls. So that's important to remember just as we go through these things. It's really like, where is the work being performed? We've also got another concerned citizen out there who has reminded us that federal contractors should remember when looking at protected leave for eligibility that hire dates typically are when, oh, this is a good point. Hire dates can be when the employee started on the contracted site and not your hire date. This is one of those things that come up in the FMLA world from time to time. You need to think about how long have they been performing work on that contract, because that could somehow kind of basically obligate you to honor their years of service previously. Really good point. I am hearing that, Sarah, we might be getting a little bit of feedback from you. Maybe we could, I don't hear it, but I'm going to trust the powers that be out there, that it's maybe, and I'll mute when you're talking as well.
Okay. Let's try that. Are folks still hearing the echo or feedback rather?
Haley, let us know. We've got one more question that I think is really important in the context of FMLA. What happens if employees try to opt out of FMLA? If they fail to submit their medical certification, couple options. Great. That's a great question. One option is, and this is unfortunately going to be one of those fact specific issues that probably we're going to talk about the state requirements as well and how long and all those moving pieces. But generally, if they fail to submit their medical certification, I would question whether they're actually entitled to the leave at all. And it's tricky because you got to stay ahead of the ADA considerations. But I think it's a requirement. It's not a may, it's a must. And if they fail to provide those documents, then they don't get approved for the leave, which means it's not protected leave. But you do as a company, I mean, the other piece is if they're not submitting that certification, not because they had a little bit of delay, because we know that the medical profession out there is taking forever to get these things, but if it's because their own decision, that further kind of cements this idea that they're not entitled to the FMLA. It's tricky though if they later on have FMLA that they're entitled to, but it's unfortunately one of those questions you have as a company decide whether you're going to provide that leave at all, because at that point they're not entitled to it.
Yeah. It almost feels like at that point they're deliberately not providing the documentation, right?
Right.
So
It's
there's some
intentional.
malintent behind it. Yeah. Okay.
So let's move on with
Policy
the,
considerations.
the policies. I'm going to try to get through some additional questions. I think
Maybe
we
it's a
might be picking up someone's voice to text, so it's also making it very hard to see the questions that are out there. But let's go forward to policy considerations there.
perfect. So I think this is sort of the big, what we generally work with clients on, right? How are we going to draft your policies to ensure that they're compliant across all the states that you have employees in? And these are the sorts of things that we think about, right? So obviously the first thing, which is not really on here, but what states are we operating in? Because that's obviously going to help sort of navigate the types of leave that are available. And what between those protected and permissible leave types, which ones are available, from you as the company. So that's sort of the foundational question. And then we're going to talk about eligibility requirements. So like we just talked about with regard to DC, right? Like, considering those state specific requirements, do we have to ensure that the sick leave is provided to all of our employees, including part-time employees, or is there no such requirement? And that way we can sort of, tailor it more to a more narrow group, right? What are the employee rights and responsibilities? Again, that could be dictated by the specific types of leave and state specific laws that are applicable. The pay and benefit implications, right? So how much do we want to, how much are we required to provide? Is there a requirement to pay out unused PTO upon termination, right? Like things like that we want to sort of navigate. Again, a lot of it dictated by state specific laws. Procedures for requesting leave, are they going to submit to a central, point of contact, human resources? Do they need to report to supervisors? Is there a time period by which they need to provide their leave request by? And what are the leave accrual, usage, and carryover requirements, right? And is there a cap that you can place on those requirements? Is there a limit that you can place on the use, for example, and things like that? What happens if the employee is reinstated or terminated? So do you have an obligation to continue providing them the leave, providing the same bucket that they had before they left and then they came back? And then ultimately, I think this is the key, question and key consideration for folks, especially as you operate as a multi-jurisdictional employer, is are we going to have one overarching policy for all of our states that is most likely going to need to be compliant with the most generous state, right? Like the state that has the most generous requirements, we're going to probably have to ensure that it's compliant with that state and then have this overarching policy that's very, very generous across the board. Or are we going to have, one policy and then the different addenda or policies for different states that we have employees in? And we see it both ways. I mean, this really ultimately is a client driven decision and what makes most sense for your workforce. If you are a company where 95% of your workforce is in DC, then it may make sense to have a DC compliant policy overall, because then you're going to, with those few employees that you have elsewhere, it's going to be hard to like administratively track the hours and do all of that. But if it's, pretty evenly across the board, then maybe not. Maybe you do want differing addenda depending on the state that they're in, and maybe providing, very, very generous benefits just does not make sense, financially or whatnot. So it really is specific to the client. We've seen it both ways, and we've seen clients get creative in what they offer, but, ultimately these are some of the, most significant things that you'd want to consider in drafting policies.
Sure. We did receive another question about FMLA that I'll just hop in. This idea, can you give FMLA if the employee is not entitled to it? Sure, you can. We see companies do it from time to time, just classifying it as FMLA. This is you burning through your FMLA. The only consideration is if for some reason you do have to ultimately terminate that position, you could box yourself in a little bit, but it's a very good option if you're having trouble getting someone to turn something in and you're pretty convinced it's FMLA certified or covered and you just don't have the paperwork. There's no legal restriction on classifying that as FMLA. The only caveat I'll add is, and this is really going outside the scope of this webinar, so I apologize, but the question of if they're a salaried employee and they are taking intermittent leave, that can be a little bit messy because basically there's an exception under the FLSA, not FMLA, FLSA, which basically allows you to make deductions from salaried employees' pay for FMLA leave. I have not looked at the question of whether if someone gets the FMLA certification wrong, does that undermine your exception under the FLSA? Again, outside the scope of this, if all you people are saying, what is all the acronyms? Please stop talking about FLSA. I apologize. It just came up, so I thought I would mention it.
Yeah, so a lot of things to consider with regard to policy crafting and ultimately these sorts of things will help navigate how you approach your policy and drafting it. And then obviously you also want to think about what your policy currently looks like and making sure that if some significant changes are made, you want to make sure that you're messaging that appropriately to your employees as well. So there's sort of a fine balance between dealing with the state specific considerations, but also how are you going to, communicate any potential changes, big changes to your employees.
For sure.
So the next slide, unlimited leave policies, our favorite.
Employees, one second. Can I just get on my soapbox and say I might be in the minority on this? I do not love unlimited leave policies. They stress me out. They are frustrating. That said, a lot of companies are going in that direction. I just needed to get that out of my system. You'll see a little bit of the frustrations. We'll go over some of them, but I just wanted to get out in front of it.
Yeah, I mean, I think to Sarah's point, you do see a lot of companies just being like, screw it all. We're just going to give everyone unlimited leave. And, we think that'll make things easier, but there are obviously complications and things to consider for that as well. Here we sort of outline the different things that you want to consider for your unlimited leave policies, if that's the route and the approach you want to take. But the first being, who is eligible, right? Like, is it going to be a specific subset of your employees? And if so, is there a requirement to be employed for, let's say, 90 days before you are entitled to, unlimited leave? So again, crafting it in a way that makes sense, and again, with financial considerations in mind and things like that. And then you want to sort of establish a process for how you're going to implement your unlimited leave, right? So you're going to want to ensure that folks give you advance notice of vacation, and on that same token, receiving advance approval, right? Because you don't want folks just all going out on vacation at once for, however long. And then you may want to set parameters for certain dates or busy seasons, right, that you want potentially folks to be around for, and making it clear that in those specific time periods, you're limited in that. So, making it clear, obviously, that there are these parameters, and making sure that if you are going to look for approving unlimited leave, that it's within those parameters and within that sort of framework that you outlined. And then guidelines, right, Sarah? So this is probably the most important thing, right? Like establishing that this is unlimited leave. So there's no accruals, there's no vesting, there's no rollover from year to year. You're not entitled to a payout upon termination. But there is a risk when we see sorts of, these sorts of policies come through for us, when we're reviewing, when folks put in like a 3-week cap on how much leave you can take. And the issue with that obviously is that unlimited leave, right? Like, you've put a cap now on the leave and the amount of leave that folks can take. So there is, obviously the risk, and Sarah can speak to it more, but, if you do place a cap, then that may, depending on the state, actually then obligate you to provide that amount of leave at the very least. And if you're not, then folks would be entitled to that leave at the end of the year.
Yeah, some states have gotten wise to unlimited, in quotes, vacation policies that aren't actually unlimited, and they have come out full swing against them. The states you would imagine, California, Colorado. I think I just gave away some answers to some of our future questions on this topic. But yeah, so you want to make sure that and there are ways, just because you can't put a cap on your unlimited leave doesn't mean you can let employees just go off and do their own thing for 6 months and not have any consequences. Like, you could have performance criteria, metrics, expectations, all of that. They still need to perform. But if they do their job, do a good job with it, and want to take a 3-week vacation, that fits within the company's business needs, generally these things can be a good fit. I will add that there is one state out there, Illinois, where the jury's sort of out on whether unlimited vacation qualifies. There's some language in the legislation that kind of makes it look like you can't have an unlimited leave policy. So it's not gonna get like a get out of jail free card in every state, but it has satisfied a lot of questions. The other thing that bothers me about unlimited, which is just sort of like a messaging, you want to make sure that it's clear that just because you have unlimited leave doesn't mean that if you are out on FMLA for 3 months, that you get paid for that entire time. So it's important to just set expectations that this applies to vacation or sick leave or whatever it is, but when you have other job protected leave, like military leave or FMLA leave or jury leave, it's something else entirely. Or there's a limit. You just need to make clear where the boundaries are. And then I joke, but unlimited leave policies can actually fill a good role.
Yeah, so a couple of things that you just want to make clear, and things to consider here when thinking about a potentially unlimited leave policy. And I think the final 2 slides we've got, if I'm not mistaken, are just some examples to talk through. There might be actually a best practices slide at the very end, but this first example, which we kind of touched on, I think, Sarah, but maybe we can elaborate a little bit more. But essentially, if you as a company have a policy that all of your unused leave is forfeited at the end of employment, right? So you're not entitled to, I guess, your use it or lose it type policies, right? But now you have employees in California and Colorado, our 2 favorite states. What should you consider when you are changing your policy, right? So I think the biggest thing, first off, is when we talk about messaging, and more so on the opposite, right? But like, obviously making sure that employees understand that, things will change, especially for those folks in California and Colorado. But, obviously in California, for example, let's just take California as an example to start. Your vacation is going to be considered wages, and therefore employees are entitled to that payout upon termination, right? And so you want to consider, whether or not it makes sense if you have one all-encompassing PTO policy that includes your vacation, et cetera. I mean, all of that will be considered wages that employees are entitled to upon termination in California. And so you may want to think about revising or making some tweaks to your policies to sort of separate out the buckets of leave.
Yeah, so if you've got folks in California or Colorado, which do unequivocally require payout, regardless of what your policy says, they will come after you if you don't pay everything out. California will come after you if you don't pay everything out by the next business day if it's a termination. So you want to make sure that that's clear and that you allow for carryover in California. But you can limit that, right, to your folks that are physically located in California. You can also put a cap on California vacation. There's no obligation to provide employees in California with a certain amount of vacation. So you've got some wiggle room to figure that out. But it is important that you know that any PTO that's earned in California and Colorado, end of the day, needs to be paid out if it's unused.
And the opposite is probably what would be received poorly by employees, right? Where you have paid out leave previously, but now you want to limit that payout. And so, obviously you want to think about, how you're doing that, making it clear within your policy that you do limit payout. Obviously keeping in mind that there are certain states like California and Colorado that you may have to navigate but ultimately, how are you going to message this to employees who have the expectation that their leave will be paid out, but now you're making this pretty significant policy change, and that's going to involve a lot of sort of massaging of your communication and how you implement that.
Yeah, depending on the state, if you have previously paid it out, it could be considered wages and vests, and you need to make sure that you are not taking away wages in that. So there are ways to do it. You just got to be a little bit careful and plan ahead. And sometimes we often see it actually where companies are moving to an unlimited vacation policy. And in that instance, you can't just forfeit all of the vacation that's been earned to date typically. So you just got to do some timing and maybe some different types of buckets, but there's a way to do it. I think we can get to is the next one best practices?
I think there's one more example. Yeah.
We've already given everyone the answers to this one,
Yeah.
ladies.
I think, again, this is what we talked about, making sure that there's a carve out for those, FMLA, jury duty, those types of leave. And, otherwise making sure that those guidelines are made clear in an unlimited leave policy. And then I think the last slide is the best practices. Oh, no.
Apparently, there are no best practices. Good luck. No, just kidding. Important. I think if we had to summarize, right, it'd be make sure that you know the state law that applies, whether it's sick leave requirements or PTO requirements. Thank you again for setting us straight that 3 states do in fact require PTO requirements. So just know what those state-specific sick leaves are. Know the state-specific FMLA law because they do differ. DC, for example, kicks in when you have 20 employees. California kicks in when you've got a basic, I think it's 5 overall. So it's just different rules apply, and they could unwittingly hook you into those FMLA requirements when you're not otherwise having it on your radar. And then, of course, the state-specific disability requirements, which are sort of separate, but it's good if you're trying to figure out a solution for your employee where they get paid. There are some useful ways that you can use those. So it's just important that you have a good lay of the land. And then once you know what laws apply, you can figure out whether they apply to this particular employee situation, whether it's a serious medical condition under the FMLA, whether it's something that's covered by the FMLA but not covered by the ADA because it's not the employee's own medical condition. All those sort of considerations are going to help you narrow in on what the applicable kind of like best practice should be. I will note that we got a lot of questions come in that I know we have not had a chance to respond to. So we will do our best, Sarah and I, to get back to you on those pieces. I will also look at that, right on 3 o'clock on the dot. And before we log out, Sarah, do you have any, rules of the road? If you're going to remember one thing from this webinar, remember this, words of advice for our attendees.
Yeah, I mean, I'm going to just echo what Sarah mentioned in that, you want to be obviously considering the state specific rules and, everything that would apply. But also, I think a big piece of this is looking at your workforce, right? Looking at the company as a whole, right? What makes sense for you, whether it's, again, are you going to have a one size fits all policy with the differing addenda, or are you, rather, are you going to have a one size fits all policy, or are you going to have the state specific policies, right? So just taking those things into consideration as well, because I think a big piece of this is, understanding who your employees are and what makes most sense, but also obviously navigating that with the state specific rules that apply and things like that. So I think, the last message here is it's complicated, it's tough. But there's ways to work through it and make sure that you're compliant. And of course, Sarah and I are available for any questions that you may have.
Thanks, everyone. And please enjoy the rest of your afternoon. And we look forward to seeing you on the next multi-jurisdictional series. Sarah and I think, are going to be talking to you in a few weeks about marijuana and drug practices and policies. So we look forward to talking to you then.
Appreciate it.